The Assembly Committee on Government Affairs will come to order. Madam Secretary, please call roll.
Assemblywoman Anderson.
Present.
Assemblywoman Black.
Here.
Assemblywoman Brown May.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Dickman. Assemblywoman Duran.
Here.
Assemblyman Ellison.
Present.
Assemblywoman Martinez.
Present.
Assemblyman Matthews.
Here.
Assemblyman MacArthur.
Here.
Assemblywoman Thomas.
Here.
Assemblywoman Torres.
Here.
Chair Flores.
Present. Thank you, Madam Secretary. Please let the record reflect that Assemblywoman Dickman is absent excused. Should she make her way into the meeting later, please mark her as present. Otherwise than that, all other members are present and we have a quorum. Good morning, members. I hope you had a great weekend and give yourself an opportunity to get some rest and hang out with friends and family. For those of you joining us virtually, good morning. Welcome to your Committee on Government Affairs. I'd like to remind you that we'll be taking the agenda in the order it appears. We have 3 bill hearings, and then we'll do public comment at the end. And we're also going to take the bills in the order they appear, starting with Assembly Bill 220, followed by Assembly Bill 236, and then lastly, Assembly Bill 337. Also, I want to remind you, those of you who are joining us for a first time, that you'll see members look in multiple directions. It's because everybody has a very unique setup with laptops, monitors, and paper documents in front of them. Don't take that as a sign of disrespect. With that, we'll start off with Assembly Bill 220. Good morning, Speaker Frierson.
Good morning, Mr. Chairman, and members of the Committee on Government Affairs. For the record, my name is Jason Frierson. I represent Assembly District 8, and I'm the Speaker of the Nevada State Assembly. I am pleased to present to you today Assembly Bill 220, which simply prohibits peace officers from using mobile applications that encrypt communications on official and publicly issued cell phones. I'll walk through the short provisions of the bill, but I want to express why I brought this bill forward. First off, I want to make it very clear that the bill is only applicable to work phones, has nothing to do with personal phones, and it is certainly not intended to prohibit law enforcement from doing their jobs effectively, and certainly nothing to do with them using their personal cell phones. This is simply, I believe, an effort to modernize our statutes with the advancement of technology and communications to make sure that we are still allowing transparency in law enforcement, but we're trying to be proactive. This is not pointing the finger at law enforcement, accusing them of doing anything wrong. This is simply adapting our statutes, again, with the advancement of technology. If our peace officers are using encrypted communications on their work phones, those communications that would normally be discoverable inherently become hidden from the public and the legal process. There are, and I'm sure we're going to get into this at some point, there are limitations to what's discoverable, and this is not intended to go after that. There are things that law enforcement has to do with the federal government, some systems that are encrypted to avoid hacking. This bill is not intended to impact that. It's simply intended to make sure that the Signal app, for example, allows for a person to disappear messages, and this will be designed to prevent law enforcement in the course of their actual duties on their work phone from implementing that part of the app if it's for the purpose of avoiding it being discoverable. So just a little bit of overview. Discovery is the formal process of exchanging information between the parties concerning witnesses and evidence that they would present in a court proceeding. This includes various types of a discovery, whether it's records, interrogatories, physical exams, various documents and communications. It's both civil and criminal. In civil cases as well as criminal cases, there's the exchange of discovery. And of course, in criminal proceedings, this revolves around the prosecutor's obligation to provide the defense with any exculpatory or potentially exculpatory information. It's reciprocal between the prosecution and the defense in a criminal context. Typically, email messages, text messages, other forms of electronic communication are discoverable so long as they're not covered by attorney-client privilege or covered by work product exemptions, such as internal reports or documents of the prosecution or the defense. A peace officer could be involved in discovery in several ways. It could be as a witness, as a defendant, as a party, especially in a civil case. In all these situations, statements, papers, documents, tangible objects in their possession, including emails and texts, would likely be subject to discovery. As technology advances, I think it's imperative on us to update our standards and ensure that we don't lose sight of transparency and fairness in the process. I'm going to go through the bill itself. Again, it's pretty straightforward, but I want to note for the committee's benefit that I did reach out to law enforcement in advance to talk about this and to talk about their practices. I was not aware that some have started using encrypted technology because of its convenience. Again, so long as it's being used appropriately, this bill is not intended to impact that. I do believe that I have, in speaking with Metro in particular, that there may be some language that they want to propose that I consider to be friendly, that makes clear that they can do their jobs using this type of technology, and they don't have to divulge what would not ordinarily be discoverable. So I think that we understand what we're trying to do and have certainly been working towards some minor tweaks to make it clear. So with that, and the bill's section 1, subsection 1 requires law enforcement agencies to develop a written policy that sets forth standards of conduct for using publicly issued and official mobile devices. Section 1, subsection 2A requires that written policies include mobile applications that are approved for use on official mobile devices. Section 1, subsection 2B prohibits the use of mobile applications not expressly approved. And lastly, the section that I believe might be subject to a little bit of adjustment, section 1, subsection 3 prohibits the use of mobile applications that use end-to-end encryption that avoid discovery. And the intention is not to prevent end-to-end encryption from being used if that is an ordinary course of conduct for officers that's approved. But if it's for the purpose of avoiding lawful discovery, that's what we're trying to get at. And so that, again, that's the section that I've been speaking with members in the law enforcement community about making sure that we don't have any unintended consequences, but simply advance our laws to deal with this new technology. I believe that this bill serves as a reasonable measure to protect public trust in our law enforcement agencies and ensure that technology doesn't prohibit transparency and accountability. Again, I'm agreeable to clarifying language that makes that intent clear, but that is the bill, and I would be happy to answer any questions at this time.
Thank you, Speaker Frierson. And with that, we'll open it up for questions. Members, I'm looking through the chat now. Members, I don't see any questions on the chat itself, but if I accidentally skipped you, feel free to unmute yourself. Speaker Frierson, it appears that at this time we don't have any questions for you. Do we have anybody joining us virtually who is wishing to speak? I'm looking now through our participants, and I don't believe we do have anybody at this time who was wishing to speak in support of this bill. So at this time, broadcast, if we could go to the phone lines to those wishing to testify in support of Assembly Bill 220.
To testify in support of Assembly Bill 220, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 611, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Flores and members of the Assembly Government Affairs Committee. This is John Piro, Johnpiro, from the Clark County Public Defender's Office. And we are testifying in support on behalf of the Clark County Public Defender's Office and the Washoe County Public Defender's Office on AB 220 as currently written. Obviously, we'll have to see what proposals the Las Vegas Metropolitan Police Department decide to propose to see where we stand after that language is submitted. But as currently written, this bill ensures the integrity of the record-keeping process. We are not an outlier in this phase. Michigan has worked towards enacting steps to prevent police officers from using the encrypted communication apps such as Signal. Text messages as part of an investigation provide truth and transparency in the investigative process. And this bill allows avoidance of Freedom of Information Act requests or any attempts to subvert the truth-seeking process in trial. This bill provides the much-needed transparency by those of us who employ law enforcement officers, the taxpayers of Nevada, to ensure that accountability and transparency is maintained, because both of those are vital to rebuilding the public trust. And if the police have nothing to hide, then they shouldn't worry about this bill at all. Thank you, and that concludes my testimony.
Thank you, Mr. Piro. Next caller in support of Assembly Bill 220.
Caller with the last 3 digits of 130, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm a Policy Director of Progressive Leadership Alliance in Nevada, here in support of Assembly Bill 220. A plan we seek to structurally transform Nevada's criminal justice system by organizing with people who have direct experience with mass incarceration and their families. In the past year, thousands of Nevadans have taken to the streets to demand an end to racist policing and police violence. Key to that goal is greater transparency and accountability from our law enforcement system. AB 220 is a step to ensure this, and we urge your support. Thank you.
And thank you for joining us. We'll continue with support on Assembly Bill 220.
Caller with the last 3 digits of 956, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, and thank you, Chair. For the record, this is Liz Davenport, LIZDAVENPORT, on behalf of the ACLU of Nevada in support of AB 220 as currently written. Thank you, Speaker Frierson, for bringing this bill. Good governance requires transparency. It promotes accountability and provides information for everyone about what our government is doing. This is vital, especially to inform areas where we should revise policy. And lack of accountability can create environments where there are potentials for abuses of power or secrecy. Transparency and accountability are critical while we are in the process of revising policing practices, and public trust is more important than ever. Law enforcement cell phone communication is government-related messaging, just like emails. Making that communication transparent, just like emails, is vital to preserving and creating public trust and important in accountability measures. End-to-end encrypted messaging obviates accountability and transparency by fostering a culture of secret messages or lack of accountability. We support this bill as written because preserving government transparency and accountability and reducing secrecy in law enforcement messaging promotes greater governance. Thank you, and that concludes my testimony.
And thank you for joining us this morning. We'll continue with callers in support of Assembly Bill 220.
Caller with the last three digits of 007. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Flores, Speaker Frierson, members of the committee. My name is Lisa Rasmussen, LISARASMUSSEN. I'm here this morning to testify on behalf of NACJ. NACJ supports AB 220. In many instances in litigation, there are times when we request discovery, we request certain communications between officers, for example, in some kind of task force related action, and we don't get anything because a lot of times the messages were done on Signal or some other encrypted app outside of what the department, particularly LBMPD, authorizes. So this bill is a good bill. I'd ask that you support it. It merely requests that the apps that are used are authorized by the department and that they're within the confines of the control of the department. These are activities and messaging that goes on in the context of the job. These aren't after work texts. These are things that are happening while they're on the job. So it's a good bill. It goes exactly to the heart of what the issue is, which is transparency, and NACJ is completely in support. Thank you for hearing my testimony.
And thank you for joining us this morning. We'll continue with support on Assembly Bill 220.
For the new callers, to testify in support of Assembly Bill 220, please press *9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you. At this time, we'll invite those wishing to testify in opposition to Assembly Bill 220.
To testify in opposition to Assembly Bill 220, please press *9 now to take your place in the queue. Caller, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, Mr. Chairman, members of the committee. This is Chuck Callaway, Callaway, representing the Las Vegas Metropolitan Police Department. Per the rules of committee, we're here in opposition to the bill as written. I believe that with some recommended language that we've given Speaker Frierson, that we will be in a position of support. We certainly support what he's trying to do. LBMPD currently has a policy on the use of mobile devices. We're 100% behind transparency. Currently, our supervisors in the field and detectives are issued cell phones. However, every officer is not issued a cell phone by the department. There is a legitimate use for end-to-end encryption, and I'm not obviously a tech guy, but my understanding is that encryption protects the message from sender to receiver, but it doesn't deal with retention of the message. That's a separate issue. End-to-end encryption is often used to protect data that might be of a homeland security nature. Some federal systems that we use require an encrypted VPN in order to access them, such as CGIS or NCIC. So our only concern is that the way the bill is currently written, it might impact some of those legitimate uses for encryption. As many of you probably know, last year in June, there were over 200 police departments that were hacked in the month of June, and personal data of officers and victims and other information that was confidential in nature was released via those hackings. We have submitted some language to address our concerns to Speaker Frierson, and as always, We really appreciate his willingness to work on this, and I look forward to being able to support this legislation. Thank you, Mr. Chair.
And thank you for joining us this morning. We'll continue with opposition for Assembly Bill 220. Next caller, please.
Caller, with the last three digits of 196, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Flores and members of the Assembly Government Affairs Committee. I'm Eric Spratley, ERICSPRATLEY, for the Nevada Sheriffs and Chiefs Association. Ditto to what Chuck Calloway said. Thank you, Mr. Chairman.
And thank you for joining us this morning. We'll continue with opposition to Assembly Bill 220.
Chair, there are no more callers in opposition at this time.
Thank you. At this time, I would like to invite those wishing to speak in the neutral position for Assembly Bill 220.
To testify in neutral on Assembly Bill 220, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Understood. Speaker Frierson, any closing remarks you may have, please.
Sure. Thank you, Mr. Chairman, and again, members of the committee. I want to thank Mr. Calloway in particular. He did provide some language. I didn't submit it because I wanted to make sure that I had legal take a look to make sure that we were all on the same page. But for the edification of the committee and folks listening, at the risk of oversimplifying it, I believe that the suggested changes would only add some level of intent. So basically, law enforcement agency may not approve for official use on a mobile device or any mobile application that uses end-to-end encryption or any other means with the intent to avoid the creation, retention, or adding lawful discovery of records or data relating to the communications. Those two components were the subject of what Mr. Calloway and Mr. Spratley and I had discussed. And I wanted to run that by legal before I submitted a formal a proposed amendment. And so I still intend to do that. I will continue working with Mr. Calloway and Mr. Spratley and members of the law enforcement community to provide something to the committee that I think really meets what I think is a simple goal of preventing the intention to avoid the creation, retention, or lawful discovery of pertinent records. So with that, I would say that I plan on continuing to work and providing something to the committee in the near future.
And thank you, Speaker Frierson. We look forward to seeing the outcome of that conversation with law enforcement. At this time, we'll go ahead and close out the hearing on Assembly Bill 220. And next on the agenda, we'll continue with the Speaker Frierson on Assembly Bill 236, which discusses the qualifications for the Office of Attorney General. Welcome back, Speaker.
Thank you again, Mr. Chairman and members of the committee. Again, for the record, my name is Jason Frierson, Assemblyman for District 8, Speaker of the Nevada State Assembly. And today I'm happy to introduce Assembly Bill 236 for your consideration. Assembly Bill 236 increases certain qualifications for the Office of Attorney General in Nevada. A little bit of background. Our state attorney general is, of course, our top legal officer in our state, representing our state agencies and the public interest of Nevada. The office oversees even our district attorneys, as well as their own deputy attorney generals in prosecuting and defending cases in the Nevada Supreme Court, defends our state in the United States Supreme Court and other federal courts on matters concerning things like water and public lands, providing legal opinions to the executive branch, to boards and commissions, district attorneys, and city attorneys. The Attorney General investigates and prosecutes offenses by state and local officers and employees crimes against older and vulnerable persons, and Medicare, insurance, and workers' compensation fraud. I believe it's time that the job qualifications for a top law enforcement officer reflect the needs and expectations that our state deserves. Over the years, the duties of Attorney General have only become more wide-ranging and complex. However, the qualifications for Attorney General have not, and they have not been updated since 1955. That's been over 66 years ago. A review of the qualifications in other states found that Nevada ranks below many states regarding the standards placed, the standards placed for candidates for Attorney General. Now is the right time to raise the standard for our chief law enforcement officer in the state and to ensure future candidates have a certain level of experience, a background in practicing law, and a meaningful understanding of Nevada's history, cultural norms, and attitudes. Currently, the only qualification to run for the office of Attorney General in Nevada is that the person must be at least 25 years old, be a qualified elector, and have been a citizen or resident of the state for 2 years at the time of the election. There's no requirement currently that the Attorney General, who's in charge of attorneys and the direction for the state in legal matters, actually have a law degree or experience practicing law. According to information published by the National Association of Attorneys General, currently 9 states have a minimum age of 26 years of age or older. 11 states have a minimum age of 25. 18 have no minimum age restriction for holding office as Attorney General, and 12 states have a minimum age of actually less than 25. The oldest minimum age is that we can find is 31 years of age in Oklahoma. And while many states have a minimum age of less than 25 or no minimum age, bar membership requirements of up to 10 years for some states imply a practical minimal age of 30 to 35 years old, depending on the length of the state bar membership. So while they don't expressly have an age limitation, they do incorporate a requirement that would have a de facto age limitation. Most, but not all states explicitly require their Attorney General to be a resident of the state. State residency requirements range from 1 year in Alaska, Arkansas, several other states, to 10 years in Maryland and Oklahoma. The 18 states that do not require state residency, do require that the Attorney General be an elector, thereby, again, residency is implied. Many jurisdictions have specific statutory constitutional requirements for bar membership, while many others don't have that requirement. 14 states provide a minimum period of time that one must be admitted to the bar before being eligible to serve as Attorney General. That period ranges from 4 years in Wyoming to 10 years in Connecticut and Maryland. So now I'll just go through the bill. In reviewing the text of the bill, you'll see that the bill makes just a couple of changes. It increases the minimum age required for the office of Attorney General from 25 to 30 years at the time of the election, increases the state residency requirement from 2 to 3 years, and adds a requirement that a person be a member of the state bar in Nevada in good standing. After reviewing the range of qualifications in other states, I believe that the changes proposed in this bill are fairly modest, but will still set a reasonable standard for future candidates for the office of Attorney General. That concludes my remarks and presentation of Assembly Bill 236. I thank you all for your time and attention and consideration. I'm glad to take any questions you may have.
Thank you, Speaker. At this time, members will go to questions, and I am now checking the chat. And we'll start off with Assemblywoman Thomas.
Good morning, Chair, and thank you for the opportunity to ask a question in reference to AB 236. Good morning, Mr. Speaker.
Good morning.
Good morning. My question is Section 1, subsection 3. Here you are saying is a member of the State Bar of Nevada in good standing. What qualifies good standing?
Thank you, through you, Mr. Chair, to Assemblywoman Thomas. When we state a member of the State Bar in good standing, it essentially is reflecting that you don't have any pending disciplinary matters that the State Bar has taken action on to suspend your ability to practice, that you've paid your dues. That's essentially it. There are attorneys that are barred in Nevada, but suspended or going through, issues with respect to disciplinary matters with the state bar. And this simply says that you need to be a member of the bar, meaning you need to be licensed to practice law in the state of Nevada and in good standing, meaning that your dues are up to date and you don't have any issues with respect to limitations on the ability to practice the law as determined by the state bar.
And follow-up, Chair, please.
Follow up, Assemblywoman.
Thank you. And thank you, Speaker. My follow-up question, actually, excuse me, I was just wondering, as you were going through the bill, I was wondering why you didn't go further in stating that a person that wants to be the Nevada State Attorney General wouldn't qualify for either 5 years of practice or 10 years of practice as in other states. Thank you.
Thank you, Assemblywoman. Again, through you, Mr. Chairman. It's always a balance of trying to not dissuade or disqualify folks that would be able to do a good job, but at the same time incorporate reasonable standards to ensure that the state is well represented. And so I think this was an attempt to strike some balance. And, we have, for example, attorneys in our state that maybe practiced for 20 years in another state and moved here and have a significant amount of experience and may do well in leading that office. So we wanted to keep it flexible and just allow for the greatest opportunity for qualified candidates to be eligible. But, it's just been a balance of how far do you go and what steps do you take to ensure that folks that are seeking this office are able to lead a team of attorneys and investigators on behalf of the state. So this is just where we landed based on comparisons to other states.
Thank you, sir. Great explanation. Thank you, Chair.
And thank you, Assemblywoman. Next, we'll go to Assemblywoman Concepcion.
Thank you, Chair, and thank you, Speaker, for bringing this bill. My question was actually asked by Assemblymember Thomas, but since I have a moment, I do want to thank you for building in a little bit more qualifications for a position as important as the Nevada Attorney General. Thank you.
And next, we'll go to Assemblywoman Anderson.
I'm going to say thank you, Mr. Chair, and thank you, Mr. Speaker, for bringing forward the bill. I'm in the same boat as Assemblymember Considine. Assemblymember Thomas brought up every single question I had. Although, reading it again, do you think that there is a possibility of some, and I realize that I'm asking you to use a kind of a forecast, do you think there's a possibility then of just having a trigger effect or a waterfall effect to impact all of our different counties when it comes to their attorneys that are elected through DA? I realize that's not in the bill itself.
Right. Yeah, that's thank you again, Mr. Chairman, through you to Assemblywoman Anderson. That's an interesting question, and it was not something that I contemplated. I want to just kind of put out there that I recognize that Nevada is so unique. It's not a one-size-fits-all state in many respects, and so for example, you can be a judge in some parts of our state without being a lawyer, and that is a reflection of I think the population And I don't want to take action that really limits small counties, for example, that don't operate like the larger counties do when it comes to those matters. I am simply unaware technically of the qualifications for, say, district attorney or city attorney in every jurisdiction to know for sure. But I did see, having worked as a deputy attorney general myself, having seen the important work that they do and the complicated work that they do, I could not imagine someone who's not licensed to practice law leading attorneys and investigators on securities fraud. I couldn't see a non-licensed person representing the state of Nevada with respect to opioid settlements or, the Volkswagen settlement case. The things of that matter that are complicated as Nevada grows. So that was why the focus was on the state attorney general. I'm now curious about local attorneys, but that certainly was not the focus of this bill.
Thank you, Mr. Chair, and thank you, Mr. Speaker. And I'm so sorry to ask you to try to do the crystal ball thing. Thank you.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Black.
Thank you, Mr. Chairman. I'm curious about SJR 8. If the electorate passes it in the next election, do you think the age requirement will stand up?
I'm sorry, through you, Mr. Chairman, to Assemblywoman Black. I have learned as speaker that I have lots of numbers scrolling in my head. So I don't know. I don't know that I understand what SJR 8's. I don't know that I understand how that would be impacted.
Because of the age, the non-discrimination based on age. Do you think that it could be argued that this is discriminatory?
I would welcome someone arguing that. I mean, I guess my answer is there is an age restriction that's in existing law. So whether we change the age or not, someone could argue that currently. So I don't know that SJR 8 would be impacting this bill any differently than it would be impacting existing law.
Assemblywoman, I don't know if you had a follow-up.
I have a follow-up on a different, it's not really a question, it's just that from my experience, there are a lot of JDs that never pass the bar that could be great constitutional scholars. So I guess I kind of understand why you're doing that or putting that in there, but I'm not sure that I agree with it because you could be a brilliant professor or whatever and maybe never have passed the bar. So how do you address that or how do you justify that? Because there are certainly, I think there's actually more people that are JDs that don't take the bar than do.
Well, thank you again, Mr. Chairman, through you to Assemblywoman Black. I would disagree that there are more JDs that don't take the bar than do. Again, having been practicing law since 2001, I think it's a rarity. I think that being a professor is significantly different than being in charge of attorneys. I think that when you are in a position of receiving evidence as a JP, for example, Justice of the Peace, when you're receiving evidence, it's up to the litigants to present their case, and then it's up to you to assess facts. Frequently sitting as a fact finder. Well, juries sit as fact finders as well, and they're not attorneys, but they're also not in charge. And so I believe being the fact gatherer and assessing what's presented to you is a significantly different function than being in charge of the process of presenting evidence and taking a position on behalf of the state of Nevada. So because there's so many incredibly important issues that are handled by the Attorney General, this isn't a case of a speeding ticket in a small county and a hearing master or a justice of the peace hearing it. This is a position in charge of handling very, very complicated matters on behalf of the state. And I don't know how one does that without understanding the intricacies and limitations of the practice of law. And so I don't know that, I don't believe in modern times this has even been an issue. I don't know that modern times that we've had an attorney general under the age of 30 or who was not an attorney. So for me, it is a safeguard for making sure that the person that handles the legal affairs for the state and supervises other people who champion the legal matters for the state is qualified to do so.
Thank you.
Thank you, Assemblywoman, and thank you, Speaker. Next, we have Assemblyman Matthews.
Yes, thank you, Mr. Chairman, Mr. Speaker. Thank you as well. Good to see you this morning. Question that I guess is somewhat related to the last question asked by Assemblywoman Black regarding subsection 3 and the requirement that the AG be a member of the bar. I'm just wondering if you are aware of or can point to any practical instances in our state's history where not having that requirement, did pose a problem if we ever did have an AG who wasn't a member and that caused a practical issue that arose, or maybe instances you're aware of where hypothetically, maybe we did have an AG who was a member of the bar, but had he or she not been, it would have been a particular issue. Just, wonder if there's practical cases that out of which this need sort of arose. Thank you.
Sorry about that. Thank you again, Mr. Chairman, through you to Assemblyman Matthews. There are lots of ifs in that layered question that I don't think I think answerable, because this bill is attempting to increase qualifications for an important position. It's not attempting to remedy a historical issue. It is attempting to prevent a catastrophe if the office of the Attorney General was led by someone who does not understand the rules of ethics for attorneys, who doesn't understand the intricacies of the various forms of litigation that the Attorney General engages in, interacting with other states and both the state and federal government. I find it difficult to imagine how someone who's not licensed to practice law would be able to supervise attorneys dealing with federal habeas corpus issues in federal court, which is part of what I did when I was at the Attorney General's office, or again, securities fraud. And so this is something that I have wondered for several years since I worked in the Attorney General's office, why we didn't already have a requirement that the Attorney General actually be an attorney. And so I don't think that, given what our Attorney General's office has handled over the years, it is worth the risk of having someone not qualified to oversee and supervise that conduct be in charge of the office. I think that it would be a disaster for, in modern times, a non-attorney to be in charge of the Attorney General's office. So maybe to some extent this is prophylactic. Again, it's as the state grows up and grows and encounters complicated matters, I think that we need to make sure that our elected officials that are in charge are up to the task.
All right, thank you so much. And thank you, Mr. Chair. Appreciate it.
Thank you, Assemblyman. Members, any additional questions? I'm going through the chat now. I don't think I see any. However, if I accidentally skipped you, feel free to unmute yourself at this time. Seeing none, at this time, I'd like to go to the phone lines and invite those wishing to testify in support of Assembly Bill 236. Broadcast, please.
To testify in support of Assembly Bill 236, please press *9 now to take your place in the queue. Caller with the last 3 digits of 864, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Yes, Mr. Chair, members of the committee, for the record, my name is Nina Laxalt, today representing myself. As a native Nevadan with pretty much a front row seat to Nevada politics my entire life, I looked at this bill and wondered what the history has been through my lifetime on these three issues of AB 236 and what it would have changed. I looked back at 10 AGs and realized that the law had been put into place right about the time I was born. So I'm looking at an entire lifetime of what we've had and how this bill might have changed our past. In Section 1, to change the age limit, if you look at what someone has to go through to be an attorney, they graduate at 18, let's say, from high school, and they go through 7 years of graduate, postgraduate. They're 25 years old. That would make them eligible at that point as a brand new graduate of law school to become Attorney General. All of our Attorney Generals in the past have been well over 30. So moving this age from 25 to 30, I believe and agree with Speaker Frierson, is a very modest change. To be in the state for 2 years, I went back again and looked at everyone that has been an Attorney General, and nearly every single one of them, sans one, have been in the state for at least 10 years, and many of them have been lifelong Nevadans. So to change it merely from 2 years to 3 gives those people an opportunity to see what Nevada is about and who we are and get a feel for Nevada as a state. And the third change, of course, is requiring that the Attorney General be an attorney. I was surprised about 15 years ago to realize that that position was not required to be an attorney. So it was a kind of a coincidence that the Nevada Attorney General is called attorney. Going back again in history, every single one of our Attorney Generals has been an attorney. So with that, I agree that these are very modest, and I believe modest is an understatement, changes to the requirements for the Attorney General. It's a very litigious society, more than it was in the 50s. And I believe that this is a very moderate, very conservative, very modest change. And I support this bill. Thank you very much.
And thank you for joining us. We'll continue with support on Assembly Bill 236.
Chair, there are no more callers in support at this time.
Thank you. At this time, we'll invite those wishing to testify in opposition to Assembly Bill 236.
To testify in opposition of Assembly Bill 236, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. At this time, we'll invite those wishing to testify in the neutral position to Assembly Bill 236.
To testify in neutral on Assembly Bill 236, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. Speaker Frierson, any closing remarks you may have?
Thank you again, Mr. Chairman, members of the committee. I don't have anything to add. I thank the committee for their attention and for their questions. It always makes for a more complete record. But I again would welcome any further questions offline, and think that AB 236 is a positive step forward for the state of Nevada.
Thank you, Speaker Frierson. So at this time, we'll go ahead and close out the hearing on Assembly Bill 236. And I see that we have Assemblywoman Gorlow, who has joined our meeting. And at this time, we'll open up the hearing on Assembly Bill 337. Assemblywoman Gorlow, whenever you're ready.
Thank you, and good morning, Chair Flores and committee members. For the record, I am Assemblywoman Michelle Gorlow, representing Assembly District 35 in Clark County. And I appreciate this opportunity to present AB 337, which creates a pilot program for one or more state employee health clinics. With healthcare costs continuing to increase while quality, access, and satisfaction with the healthcare system declines, many employers have decided to optimize their benefit dollars by offering on-site or near-site clinics to their covered populations. Primary care services for employees can modify their lifestyles and move employees toward a more optimal state of wellness. They can also produce organizational and employee benefits such as lower healthcare costs, increased productivity, improved recruitment and retention, reduce absenteeism, and enhance employee engagement. In recent years, many states have begun offering these services, including Colorado, Kentucky, and New Jersey. Kentucky's employee health clinics conduct preventative health education, medical screenings, and lifestyle modifications to ensure the best health for their employees. Their services include urgent care, immunizations, treatment of minor injuries that are non-work related, treatment of illnesses such as colds and flu, and well as wellness screenings. They also provide management services for conditions such as diabetes and hypertension in cooperation with a primary care provider. An employer-sponsored health clinic can serve as the hub of a worksite wellness program, making it able to integrate and analyze all the data from health-related programs and activities. At the same time, the on-site clinic staff can increase the engagement of workers in preventative condition management programs. These type of population health approach may identify unnecessary services, gaps in care, opportunities for savings, and quality improvement. In 2017, the PEB board put out a request for proposal, which is known as an RFP, to explore the possibilities of an on-site or near-site primary care clinic. Unfortunately, the one company that responded could not commit to the return on investment that was expected in the RFP. Since that time, the PEB board has not explored the feasibility of on-site or near-site clinics. However, in the last few years, many other companies have entered the market and have proven they can effectively accomplish a high level of return on investment while providing more benefits at reduced costs. So as written, Assembly Bill 337 allows the PEB board, to the extent money is available, to create a pilot program to establish one or more clinics to provide primary care services to state employees who participate in the program. There is a conceptual amendment that will be discussed shortly. If the pilot program is created, this bill requires the board to solicit feedback from employees that use the clinic and also report annually to the legislature concerning the pilot program. This concludes my prepared remarks. I would like to turn it over to Edward Ablisser to discuss the amendment. And I also have Laura Freed, the PEB board chair, and Laura Rich, PEB's executive officer, here to answer questions.
Thank you, Assemblywoman. I'm going through the chat now and going to try to take the questions in the order they arrived. Members, I don't see any questions that have arrived via chat. If I have missed you on accident, please feel free to unmute yourself and state your name for the record. Eddie, were you hoping to jump in now?
Mr. Chair is going to give prepared remarks and discuss the conceptual amendment as well.
Thank you. And I did just get a question now. Sorry about that, members. So let me hold off on that and we'll let Mr. Abler do his thing first, please.
Okay, thank you, Mr. Chair. Good morning, honorable members of the Assembly Government Affairs Committee and Honorable Chair Flores. For the record, my name is Eddie Ablisser, E-D-D-I-E, A-B-L-E-S-E-R, and I'd like to thank Assemblywoman Michelle Gorlo for her work and the work of Executive Director Laura Rich from PEB to craft language that can create this opportunity for tremendous benefit and value for on-site and near-site primary care clinics for the state of Nevada employees. This bill, along with the conceptual amendment, is pretty basic. What the bill does is ask PEB to release an RFP, such as what they did in 2017, solicit responses that might not be, which in 2017 might not have been financially viable, but is today, and might meet their ROI that was originally idealized in their RFP. This bill in no way commits the state or PEB to administer an on-site or near-site program, but instead requests solicitation responses to determine if it can be done. To that point, the conceptual amendment does three things. First, in subsection 1, it adds at the discretion of the board in making determination of monies available. We understand that there might be more dollars coming from the federal government or new economic forecasts that might bring money to PEB. And with the recent PEB cuts and other changes in their offering to state employees, we understand that those probably take priority, and we didn't want to have language that bound their directive or their dollars. So providing discretion of the board, I think, satiates that point concerning being bound to spend those monies, new monies, just on this program. The second amendment in subsection 1 adds language of on-site and near-site. This should have been in the original draft. It was left out mistakenly. Obviously, this is all about on-site, near-site primary care clinics for state employees. And so we needed that into the bill. And finally, there's a new subsection 4 in the Conceptual Amendment that instructs the Division of Purchasing to assist PEB in the solicitation of the RFP. We understand that they are very busy and overwhelmed as a department, as most departments are, and there's value in adding the Division of Purchasing to assist departments in soliciting and reviewing RFPs. In regards to the fiscal notes submitted by PEB, I think it's important to note that those numbers were based on the 2017 RFP, and the only one response that they got back from a potential operator. Passing this bill does not bind PEB into engaging into this program, nor compel them to accept any vendor. Any costs to PEB occur only if the board chooses to move forward with this innovative healthcare effort. And moreover, PEB can possibly receive, should strong RFPs be responded to, innovative cost saving measures that might end up saving PEB significant dollars. In the age of COVID-19, when more and more workers are coming back to the workplace and more concerns about public health, employers across the country are turning to nuanced on-site primary care clinics to help mitigate the risks and anxiety that comes with reentry to the workplace. These privileged clinics are perfectly situated for same-day access, comprehensive health integration like pharmacy, labs, procedures, and giving state employees a concierge style of health services, all the while saving the state significant dollars that are associated with the loss of an employee to leave the workforce and go to a doctor's office that might be across town, generally days or weeks after exhibiting symptoms. In 2019, Milliman's study found that in Union County, North Carolina, their claim costs were lowered by 20%, hospital admissions were lowered by 25.5%, and their ER visitations decreased by 40%, all with the implementation of these near-site or on-site primary care clinics for their government employees and families. States such as North Carolina, New Jersey, Colorado, Kentucky have made these effective on-site, near-site primary care clinics pervasive for all their state employees. And they're realizing roughly 40% reductions to overall costs in their healthcare system. Other states and municipalities are using these clinics to drive down these costs, but more importantly, provide access for employees that generally don't have access to care by having it on site. I want to thank the committee for your time and Assemblywoman Gorlow for her innovation in bringing this bill forward, and Executive Director Laura Rich for her collaboration and feedback along this process. And I'm available for any questions as well. Thank you.
And thank you. And with that, we'll go to questions. We'll start off first with Assemblyman Ellison.
Thank you, Mr. Chair. We're trying to still get the amendment to download. We haven't got that yet. But one of the questions I've got is, it looks like this would be a cost savings back to PEBs. But at this point in time, if AB 37 passed and they did get some people to take a look and bid and put a program together, at that point in time, would it have to come back to this board, or is something that the director can implement at that point in time from PEBs?
Thank you very much for the question, Assemblywoman Michelle Gorlow, for the record. To you, Assemblyman Ellison, through Chair Flores, if I can, I would like to turn that question over either to Mr. Ablisser or to Laura Rich.
Thank you.
Thank you, Assemblywoman Gorlow and Mr. Chair. I would say that the bill instructs PEB and the board to administer and move forward with this procedure. The way I read the bill, that does not need to come back to the legislature. Only reports about the success or perhaps failure of the program comes back to the legislature. But should a vendor with a very competitive and strong proposal present itself to the board, and should they choose to move forward, they have the right to do that independent of what I believe the legislature needs to accomplish based on this bill. And Executive Director Rich, I don't know if you want to add to that in any way.
This is Laura Rich, for the record, Executive Officer of the Public Employees Benefits Program. Mr. Abler is right. This appears to give the PEB board the ability to move forward without going back to the legislature. However, I do want to go back and just make a couple corrections to statements that have been made. There were actually, when PEB did this in 2017, it was an RFQ that went out, and we did actually receive 3 proposals. Only one of them met the ROI requirements, or only one vendor was willing to meet the return on investment requirements that had been inserted into the solicitation at the time. And after we got into the negotiation phase, the return on investment was that vendor was unable to to really drill down to the ROI requirements that PEB at the time needed.
Thank you. Assemblyman Anderson, did you have a follow-up?
Yes, I do, Mr. Chair.
Please.
And I think that if they put the RSV out to, I think either one way or another, I think it should come back as a information, maybe not as a BDR, but at least as a work session to give the body an idea where they went and how they come up with and what they come up with at the end.
Okay. Next, we'll go to Assemblywoman Anderson.
Thank you, Mr. Chair, and thank you, Assemblymember Gorlow, for bringing forward a possible way for us to save some money and help our public employees. My question has to do with Section 1.1, where it states the primary care. Would that include mental health services, or is that only the physical health services, and including the pharmaceutical health?
For the record, Assemblywoman Michelle Gorlow, and thank you for the question, Assemblywoman Anderson, to you through Chair Flores. I believe that would have to be based on the RFP that would be returned from the provider on what services they would actually be providing, and then the PEB board can look those requirements over and decide which vendor would be best suited for the on-site or near-site clinic. However, I might need some clarification from Laura Rich or Mr. Ablisser on that.
Sorry, go ahead.
For the record, Laura Rich. So yes, Assemblywoman Gorlow is correct. It would depend on how intense you wanted to set up that clinic and what kinds of services. Now, remember, the more services you include in this clinic, the more the level of expertise you have to have, and you have to understand that there's specialty care that occurs, and so you'd need those specialists to be staffed at that clinic. The more specialty services that are included, the higher the cost is, and the more engagement that PEB would require in order for this clinic to be considered a cost savings. primary care is not necessarily a cost driver in PEB, and it's more on the specialty side. Access is also an issue too, where it's not an issue in primary care, but it is an issue in specialty. And so when we originally looked at this back in 2017, that was one of the problems, is that first of all was the location. Where do you put this clinic to so that state employees can access it? So at the time we were looking at in the Las Vegas market, we were looking to pilot it in Las Vegas because Las Vegas has more access issues than say Northern Nevada. And so we were looking at where do we put this on-site location so that state employees are able to access it and it has a benefit to our state employees and to the cost of PEP. The problem with that is that our state employees are widespread, especially in Las Vegas. There's no central location where you have a population density of state employees. You do at the university, say, but the university already has their own clinic. And so it didn't make sense to do it there. So you have to centrally locate this in a population density that is going to be used by state employees. The problem that has made it even more challenging today is that people are now working from home, and I suspect that that will continue. And so again, there's no longer a centralized workplace where these people are going to access the clinic. So this just now becomes just another option, another primary care option. And so that's where we struggled with the return on investment, is there was that you have to have high utilization. And so in that situation, if you have high utilization, you have to then motivate people to use that clinic. And so it's you're either going to motivate them with convenience, which we don't have, or you motivate them with a different plan design. So for example, maybe you incentivize with a lower copayment to use this facility. What ends up happening is we then have disparity issues. So if you put this clinic in the South and you're offering a statewide plan, and we say, okay, if you use this clinic in the South, it will cost you $10 to use it, a $10 copayment. The people in the North don't have that access, and so you have disparity issues between plan design. So that was another challenge that we had as well.
Thank you, and thank you for that clarification. I realize that it's a very difficult area to consider. Has there been any discussion, and this will be my last follow-up, I promise, Mr. Chair. Has there been any discussion about telehealth and utilizing that possibly, or since this is coming back, I know that it was not very popular or very well known in the 2016 timeframe, but it's now becoming something. Is that currently something that is part of the plan, or is that just a possible discussion for the future?
So Laura Rich, for the record, it would have to be a part of that of the RFP. I would assume that yes, now with the option of telehealth and the more utilized option, I think people are more receptive to using telehealth, and I think providers are more capable of offering telehealth. That would also be a service that would be provided should this be something that PEB moves forward with.
Mr. Chair, through you to Assemblywoman Anderson, Eddie Allister for the record. To both of your questions, Assemblywoman, many new nuanced on-site primary or near-site clinics have integrated mental health, lab work, pharmacy, even some certain specialty clinics nearby are integrated into their sites. We've seen this in Colorado and New Jersey. to large effort and tremendous success embedded in that process, and telehealth, where they have a robust telehealth offering. You know, the cool and like sort of privileged ideas about these near-site, on-site primary care clinics is they're privileged to the employees and their families. No one else accesses them. And so you, to Director Rich's point, finding a location that is perfectly centered and for enough employees and their families to access it so that the usage rate it creates that ROI that PEB might visualize should they get a strong proposal from the RFPs that are submitted.
Thank you, and thank you, Mr. Chair, for that much time. Thank you for the answers.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Black.
Thank you, Mr. Chairman. My question is for Director Rich. I was looking at the RFQ, the bids that came back in 2017, or the numbers, I guess I should say, 1.3 million to set up the clinic, 3.75 million a year to run it. It obviously didn't make sense then. I assume now things are just more expensive, and then you added another layer on to this, which I didn't think of, which is most people are, well, a lot of people are now transitioning to working from home. So I'm curious, do you feel that there's something that changed in the last 4 years that's made this more feasible?
For the record, Laura Rich, there's definitely a lot of challenges with this, and whether it is more feasible today than in 2017, my opinion is that, you know, there's different services that have been offered, or that, you know, again, like telehealth is more, people are more receptive to it, and costs are, there's not just in the legislature, but also plans, self-funded plans are addressing the way that telehealth is billed and things like that. And so there's some changes in the market. I can't say whether this would be more beneficial or if things have changed enough to change the direction of the board. Regardless, there's always going to be startup costs. So there's those implementation costs. You're still going to have to find a physical space. You're still going to have to furnish. You're still going to have to staff. PEB will have to have additional staff to take on a project like this as well. So there's still going to be those upfront costs that will never go away. Whether there is cost savings involved, when we did this a few years ago, we determined, because primary care is, again, not a cost driver, where we determine the ROI would be is potentially in steerage. And so, for example, today, if a person goes to a primary care facility and they go see the provider, and their provider says, you know, you need to get imaging done. And so they just send them to whatever imaging they feel that they want to recommend them to, refer them to. Those facilities there's a lot of discrepancies between pricing and imaging between one facility and the other. And so what PEB would do in this type of scenario is steer to those high quality, low cost facilities versus the high cost facilities. But we were just not able at that point to really get the vendor to come up with methodology and really ROI methodology that both PEB and the vendor were willing to agree on and stand behind. The most we could get was a 1-to-1, so we would come out even. So we were not seeing a cost savings, and that's why we at the time chose not to move forward.
Follow up, Mr. Chair.
Follow up, please.
So I love the idea of telehealth, especially since I'm from a rural community. I think it's going to make great differences in people's lives. However, at some point, we all have to go to an actual brick and mortar building. So maybe, I mean, this is just an idea, maybe PEB could implement at first a telehealth kind of system to try it out. But otherwise, I'm with Assemblyman Ellison. I think that this should have gone out for an RFQ, and the body should have seen if this was even a feasible idea before we talk about a bill.
And I'll take that just as a general statement rather than a question. I am looking through the chat to see if we have any additional questions. I know some folk had some questions, but I believe during the back and forth exchange with other members, some of the questions were addressed. I'll go to Madam Vice Chair Torres.
Thank you, Chair, and thank you, Assemblywoman and co-presenters for the presentation. I appreciate it. And I just wanted some clarification. So as I read the bill, and I understand that there's an amendment that I haven't had the opportunity to take a look at, but I'm just confirming that this is permissive language for them to do that to the extent that this is possible, correct? And this is not compulsive language requiring them to enact it?
Thank you for the question, Vice Chair Torres. For the record, Assemblywoman Michelle Gorlow. And yes, this is permissive to give them the ability, and also not only to be able to send out the RFP or RFQ, but also based on any funding that they may have as well. So if the board determines that they don't have the funding to move forward, then they do not have to do this.
Thank you, Assemblywoman. Just, I think with that language, that helps me kind of just understand where the legislation is, and I think hopefully answer some of the concerns of my colleagues. Because as I look at the legislation, it kind of, to me, it seems to empower the board to make that decision whether or not this is something that would be feasible. But I'm definitely interested in hearing if there's other language that would help clarify that, perhaps, so that the board would find that, and perhaps some type of amendment, just allowing for the board to determine the feasibility of this would be helpful.
Thank you, Vice Chair Torres.
Next, we'll go to Assemblywoman Brown May.
Thank you, Mr. Chair. Thank you, Assemblywoman Garland, for that presentation. And really just following up on the questions of my colleagues, I was of also the position that this is enabling language, but further supports the intent that it's the desire to actually care for our folks that are in this program, right? So that medical should be a focus. Is that really where I'm heading? And then, of course, the utilization of telehealth as we continue to expand that. Potentially brick and mortar position would not be as readily necessary, and then working with other partnerships. Now, I have seen something like this done in the past in a for-profit organization working really hard to support their employee base. So I think that the utilization would be probably the most necessary to ensure that folks could go to this clinic or on-site or near-site clinic relatively, but I just want to follow up again on that language. It was really, this is enabling and identifies the desire to support people in medical care. Is that correct?
For the record, Assemblywoman Michelle Gorlow, and thank you for the question, Assemblywoman Brown May. Yes, this is enabling again, and just allows the board to look at RFPs and RFQs to determine if there is another organization that might be able to meet their needs. And what those needs are, again, would be determined by the board on what they decide based on employee feedback.
Members, any additional questions?
Mr. Chairman?
Yes.
This is Laura Freed. May I chime in with your
Please,
ruling?
we're getting a strange little feedback. I just wanted to put that on your radar.
Oh, how odd. Better now?
Let's try it for a second here, see how it goes, and I'll get some feedback from our team, see if for minute purposes it works.
Okay. For the record, my name is Laura Freed. I serve as the Director of the Department of Administration. I also serve as the Chair of the Public Employees Benefits Program Board. I wanted to chime in and thank you, Mr. Chairman, for the opportunity to point out, after a couple of questions or folks seeking confirmation that it enables the board, the PEB board under current law has domain over plan design. So if there is a groundswell of need for primary care, then the board already is empowered to react to that by changing plan design or suggesting enhancements in the budget process that would address the needs of the membership. So, to the members who have suggested that maybe an RFQ and then putting it in the budget would have been the process, yes, that's absolutely a way the board might do that. So I just wanted to get on the record that the board could do this without this bill if it wished to do that. Really, the question just comes down to available subsidy dollars to fund plan design changes. Thank you, Mr. Chairman. I appreciate the opportunity.
And thank you. Members, any additional questions? If I accidentally skip somebody, please feel free to unmute yourself at this time. Seeing none, thank you for the conversation this morning. I appreciate everybody joining us and participating in that dialogue. At this time, we'll go to the phone lines and invite those wishing to testify in support of Assembly Bill 337.
To testify in support of Assembly Bill 337, please press *9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thanks. At this time, we'll go to those wishing to testify in opposition to Assembly Bill 337.
To testify in opposition to Assembly Bill 337, please press *9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Next, we'll go to those wishing to testify in the neutral position. Assembly Bill 337.
To testify in neutral on Assembly Bill 337, please press *9 now to take your place in the queue. Caller with the last 3 digits of 237, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. My name is Marlene Lockhart, representing the retired public employees of Nevada. I am testifying in neutral today on this bill, but have significant concerns and questions that this bill raises for our members. First, it is very difficult to testify appropriately when the amendment is not posted, and we have not had the benefit of seeing what language changes may be in the amendment. For example, the bill definitely states that the board shall shall create a pilot program. However, testimony referred that it was optional. And so I wonder if that's one area that is contained in an amendment. But probably the primary issue is the cost of this program at a time when PEB is cutting benefits for seniors, retirees, and state employees. We do not feel that this is the time to embark on a program that would cost so much money to the state. And secondly, this directs the board to take a specific course of action, which would take away their flexibility of considering telehealth and other options that may emerge in the changing marketplace of healthcare. And I was there in 2017 when the pilot program was presented before. And while we do not oppose such a program and would welcome additional access, we think it's a matter of priorities at this time to take a closer look at what this bill, how this bill would impact the PEB board as well as the members of participants of the PEB program. Thank you very much.
Thank you. And, you know, I think I'll let the record reflect that that could fall in opposition. I understand that we often walk cautiously, respectfully with bill sponsors and folk, and we don't want to send a message of opposition that you don't want to work with them and or that you somehow, you know, personally oppose a particular member or anything like that. But I think with how the concerns were presented, I believe that is opposition. So we'll go ahead and do that. Thank you for joining us, and we'll go on to those wishing to testify in the neutral position. Assembly Bill 337.
Caller with the last three digits of 111, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Flores and members of the committee. For the record, I'm Tom Burns, B-U-R-N-S. I'm the president of Cragen and Pike Insurance, as well as the immediate past chair of the Vegas Chamber of Commerce, a member of the Board of Trustees in Government Affairs. I apologize, Mr. Chair. I had a technical difficulty when I was trying to chime in opposition, but I will be very brief. My remarks reflect the previous caller's concerns and are really reflective of our knowledge without the possibility of digesting the amendment. So while the Chamber supports affordable and accessible health care for Nevadans, the Chamber is opposed to Assembly Bill 337 from the perspective of Nevada taxpayers. While we recognize that Assembly Bill 337 would be a pilot program and it would be done only if funds were available, we have concerns about the potential costs that would occur in establishing the primary care facilities. The impact that would have on PEB's existing operating budget and staffing levels would be another concern. Startup costs for such healthcare endeavors are costly. Ongoing operations of these types of clinics are another issue of concern. As someone who's worked in the insurance industry for more than 30 years, it is my experience that the cost and performance are the two biggest challenges associated with operating these clinics. Chair Flores, I apologize for my technical flaws, and I appreciate your time and indulgence.
No worries. I understand we have issues with technology as we've all become all too familiar with. So just for the clarity of the record, that was in opposition to Assembly Bill 337. And we'll move on to those wishing to testify in the neutral position, Assembly Bill 337.
Chair, there are no more callers in neutral at this time.
Thank you. Mr. Ablisser, again, thank you for joining us. And Assemblywoman Gorlo, I don't know if you had any closing remarks or if you wanted to hand that over to anybody else, please.
Thank you, Chair Flores and committee members. I'll be brief with my closing remarks. Just want to thank everybody for considering this measure and taking the time to listen to it. I also want to thank those who called in. I apologize for that amendment not being up. However, in that amendment, it should say may, not shall, which is in section 1. And we will continue to work with everyone to make this a better bill and keep everyone informed. So thank you very much.
Excuse me, and thank you, Ms. Laura Freed, and to our director, thank you for joining us today. Appreciate the thoughtful dialogue. So with that, we'll go ahead and close out the hearing on Assembly Bill 337. And next, we'll move on to public comment. Those of you wishing to join us this morning in public comment, please know that this is not a time to reopen a hearing. It is a time for you to join us and speak in general matters that fall within the purview of our committee. I want to encourage you to speak and join us this morning, but if you try to reopen a debate on a hearing, we'll have to cut you off. So with that, we'll go to the phone lines for public comment.
To take place in the public comment queue, please press *9 now. Chair, the public line is open and working, but there are no callers at this time.
Thank you. At this time, we'll go ahead and close out public comment. Members, tomorrow, Tuesday, March 30th, we have 3 bill hearings. We'll have Assembly Bill 249, Assembly Bill 340, and Assembly Bill 378. Please make sure you give yourself an opportunity to review those ahead of time. And we'll be starting at 9 a.m. Appreciate the dialogue this morning. This meeting's adjourned.